I have very carefully listened to the concerns from the chosen persons and the prosecution. The concerns and the reply from the prosecution are on court record. I will not reproduce it. And for the interest of time, I will give a summary of my ruling, and I will avail to you a detailed one later. But briefly, the issue before this honorable court is the issue of legal representation. Today, the matter is coming for hearing. The prosecution told the court that they had witnesses around the court. And the prosecution said that they were ready to proceed. However, the chosen persons, specifically A1, raised some concerns. Briefly, they are the concerns that affect the legal representation. To be specific, the concerns he raised is that, one, that there is a pending application number 248 of 2026, which is still pending before this honorable court, and is related to the issues of legal representation. According to the chosen persons, that is A1 and A2, they told the court that this application should be disposed of first. I will come back to that. They also raised the issue, the chosen persons, of the disclosure. The chosen person said that the disclosure was made to their lawyers, who have since voted a challenge. And for them, they have not received the disclosure. I will also come back at it. The chosen persons also informed the court that they want to be availed with the record of proceedings in this case and the applications, which I will also come back to. Another issue of concern was that the facilities in prison, which prison brought this honorable court as of the 29th June, that the same be availed to the chosen and their team. Another concern is by S3, who raised the issue that he was not given a copy of the ruling in his bail application. Briefly, I will now proceed to make the following remarks and findings on those summaries of the concerns raised by the chosen persons. One, I am very well aware and alive of Article 28 of the 1995 Constitution. Briefly, Article 28 provides for the right to a fair hearing. I will go ahead to Article 28.1. Article 28.1 provides that in the determination of civil rights and obligations for any criminal charge, the person shall be entitled to a fair, speedy, and public hearing before an independent and impartial court or tribunal established by law. I have also considered Article 28(3)(d) of the 1995 Constitution. It provides that is 3D, that every person who is charged with a criminal offense shall, D, be permitted to appear before the court in person or at that person's own expense by a lawyer of his or her choice. Indeed, from the time we started this case, the accused persons were permitted the lawyer to the services of the lawyers of their own choice. Not until 30th June and specifically 3rd July, when the lawyers of their own choice that had been representing them were not present in court. I will now go to Article 28, 3E. Article 28, 3E of the 1995 Constitution provides that, I quote, in the case of any offense which carries sentence of death or imprisonment for life, the accused is entitled to a legal representation at the expense of the state. In this instant case, and specifically the concerns raised by the accused persons, I will address all their concerns one by one for the interest of justice. Concern 1, that miscellaneous supplication number 248 of 2026, which is allegedly to be pending before this honorable court, or specifically before me. Cases normally allocated to the judges. Judges don't allocate cases to themselves. I want to make it clear that from my knowledge, miscellaneous application number 248 of 2026, which the accused persons are talking about, has never been allocated to me as a judge. It's not before me. But the registrar can find out from the registrar who allocates cases. But the said application has never been allocated to me, and the same application I cannot use it or debate it to hold this trial, because it is not until that the same application is allocated to me that I would know the content. But at this stage, I don't know the content of that application, which has never been allocated to me, that I can form a mind to hold this trial in session number 335 of 2025. I will go to the issue of disclosure. The accused persons have told the court that the disclosure was made to their lawyers. True, from court record, the final and full disclosure was made on the 1st of June 2026. And I will take what the accused persons have told me, that they have never received such a disclosure since the disclosure was received by the lawyers who have since got challenges. I now order and direct the prosecution that for the interest of justice, at the end of this sitting, I'm ordering you make avail all the disclosure to the accused persons before court here on their own, since the other one, according to them, was made to their lawyers. So at the end of the sitting, prisons kindly hold on around the prosecution to avail all the evidence they intend to use in this case, to avail it to the accused persons themselves. In case there is any challenge of the Constitution to do that serve all the evidence they thought rely on today, of which I believe, and they thought court that they were already with witnesses. I guess they had that evidence they intended to use, so avail it to the accused persons themselves. On the issue of proceedings, in this case and in other applications, I'm directing the Registrar of Criminal Division to avail the copies. In any case, the proceedings are by transcribing. So the IT should help the registrar to have these proceedings in this name case and applications, so that the registrar can certify them and serve the accused persons. This one can be done by tomorrow, which is 14th. And let the registrar, the IT, together with Zira prison, they should get these proceedings and avail them to the accused persons. I will now proceed to the facilities in Zira. As the accused persons, and specifically A1, 40, it is on record that at least by 29th June, the Zira people wrote this honorable report, and the letter is in record, that they had granted almost several facilities to the accused persons and their legal team, and directing Zira to adhere in the same. I want also to go ahead and comment on the ruling for S3, that it was unfortunate that you have not received the copy of the ruling. Yet this court directed the registrar and the Zira people to avail you with this ruling. I will now again direct the registrar and the Zira people, even the Zira people, before you go, make sure that you find out where it is, whether the registrar or the Zira, so that S3 is able to get his copy. For the interest of justice, and specifically to address the issue of legal representation, the chosen persons have been represented by lawyers of their choice as per Article 28, 3D, from the time we started this case, at the time of the pre-taking. However, it is my considered view that the chosen persons were permitted to have lawyers of their choice from day one. But since this court keeps getting concerns from the chosen persons that they have challenges with their legal representation, specifically lawyers of their own choice, this honorable court will move to look at the relevant laws. In case such a challenge keeps on, because my view is that there must be a solution for the trial to commence, and I am aware and alive of the right to the fair hearing. And my view, this case has suffered several delays, and indeed the chosen persons have said they have been in remand for some time. So this honorable court has decided to invoke Article 28(3)(e), which provides that the chosen persons are entitled to legal representation at the expense of the state in the cases of any offense which carries a sentence of death or imprisonment, life imprisonment. In the view of the above, the registrar, criminal division, is directed to avail